Good day everyone, I am Eliza Marie C. Alonde of Y1PMG03 Naphtali and I will be reporting the Article 1156. Under the Article 1156, obligation is defined as a juridical necessity to give, to do, or not to do. But first, let us know what is an obligation. The term obligation is derived from the Latin word obligatio, which means a tying or binding. It is a tie of law or a juridical bond by virtue of which one is bound in favor of another to render something, and this may consist in giving a thing, doing a certain act, or not doing a certain act. Manresa also defines the term as a legal relation established between one party and another, whereby the latter is bound to the fulfillment of a prestation which the former may demand of him. The Article 1156 gives the Civil Code definition of obligation in its passive aspect. Our law merely stresses the duty of the debtor or obligor who has the duty of giving, doing, or not doing when it speaks of obligation as a juridical necessity. When we say that an obligation is a juridical necessity, it simply means that in case a debtor failed or refused to perform the obligation, the creditor can do legal remedies. It means whether he likes it or not, the debtor must comply with this obligation, or else his failure will result in some negative or unfavorable legal repercussions. People can flout obligations with impunity if they are not made enforceable. If a legal commitment cannot be enforced, it may only be a natural obligation. There are two kinds of obligation under the Civil Code. First is the civil obligation. This means that if the debtor failed or refused to comply with the obligation, the creditor can do legal remedies like, for example, filing a case in the court. Next is the natural obligation. This means basically that they are founded on voluntariness of actions. As a matter of right, the natural obligation can't be enforced through the courts of justice. Nevertheless, if the debtor volunteered to perform the obligation, then he or she can no longer recover what has been delivered or rendered by reasons of the natural obligation. For example, if an obligation is based upon a written contract that is under the law, the obligation will prescribe in 8 years. For example, Ms. Chua, who is the debtor, borrowed money today, and the contract is in writing, and the debtor promised to pay on September 9, 2022. If in the promised date, the debtor didn't pay, then Mr. Anton, who is the creditor, has 8 years from the time the obligation became due and demandable to file a case in court. But if after 8 years, the creditor did not file a case in court, then the obligation of the debtor has already expired. This simply means that after 8 years, the creditor can no longer file a case in court. But suppose despite the fact that the obligation has already expired, the debtor is still volunteered to pay his obligation to the creditor. The question is, can the debtor recover what he has paid? The answer is no, because although the obligation is no longer a civil obligation because it was expired when the creditor failed to enforce his right within 8 years, it became a natural obligation. Remember that the essence of the natural obligation is the voluntariness. If the debtor volunteered to perform the obligation, the debtor can no longer recover what he has paid. In an obligation, there are essential requisites. These are considered as the building blocks of an obligation. We wouldn't have any obligation if one of these were absent. First is the passive subject, which is the debtor or the obligor. Next is the active subject, which is the creditor or the obligee. Next is the object or prestation, which is the subject matter of an obligation. And lastly, a juridical or legal tie, which is the efficient cause of the obligation. For example, Ms. Park and Ms. Goom entered into a loan contract where Ms. Goom promised to pay her 200,000 debt to Ms. Park within 2 years. In this example, Ms. Park is the active subject because she is the creditor, while in the other hand, Ms. Goom is the passive subject because she is the debtor. The 200,000 debt is the object or prestation, while the contract is the juridical or legal tie. Let's now proceed to the obligation versus right and versus wrong. Obligation is the act or performance which the law will enforce. In the given situation, the obligation is on the part of the debtor. Next is right. Right is the power which a person has under the law to demand from another any prestation. In the given example, the creditor has the right to demand payment. Lastly is wrong, or the cause of action, is an act or omission in violation of the legal right or rights of another. In the given situation, if the debtor failed to pay on due date, then Ms. Park or the creditor has the cause of action to file a case against Ms. Goom, who is the debtor. Take note that the wrong or the cause of action can be either an act or omission. It is possible that a debtor violated the right of the creditor because he did something which not supposed to do. It can also be in a way of omission, which means that the debtor did not do something or did not give something with his obligation to do. Let's now talk about the essential elements of cause of action. Its essential elements are a legal right in favor of a person by whatever means and under whatever law it arises or is created. Next is a correlative legal obligation on the part of another or the debtor to respect or not to violate said right. An act or omission in breach or violation of said right by the defendant with consequential injury or damage to the plaintiff, for which he may maintain an action for the recovery of damages or other appropriate relief. If any of these elements is absent, the complaint becomes vulnerable to a motion to dismiss on the ground of failure to state a cause of action. A cause of action only arises when the last element occurs, at the moment a right has been transgressed. Let's take a look at these illustrative cases. Mr. Stanley rejected or canceled a contract to sell his property even before the arrival of the period in the exercise of the option to buy by the purchaser who has already made a down payment. Mr. Stanley and Mr. Burt entered into a contract to sell whereby Mr. Burt, after making a down payment, was given the option to pay the balance of the purchase price of a parcel land. Later, Mr. Stanley rejected the contract to sell even before the arrival of the period for the exercise of said option on the ground that the terms and conditions of the contract are grossly disadvantageous and highly prejudicial to his interests. Mr. Stanley sent 2 checks to Mr. Burt in an apparent effort to return the down payment. Mr. Stanley contends that the complaint was prematurely filed because at the time of the institution of the complaint, Mr. Burt has yet to exercise his option under the option buyer clause of the contract. The issue here is, has Mr. Burt a cause of action against Mr. Stanley for prematurity? The answer is yes. All the elements of a cause of action are present. Mr. Stanley rejected contract to sell in no uncertain terms. Let's now proceed to the cause of action based upon a written contract. Actions based upon a written contract should be brought within 10 years from the time the right of action accrues. The cause of action in an action to cancel a contract of sale on an installment basis for non-payment arises when the last installment is not paid. When an overdraft agreement specifies that the obligation is payable on demand, the breach begins only when the demand is made. In a loan contract with a real estate mortgage, under which the creditor could unilaterally increase the interest rate, if the creditor foreclosed the mortgage when the debtor failed to pay the loan, the cause of action for annulment of the foreclosure sale should be counted from the date the debtor discovered the increased interest rate. Where the agreement to buy and sell was contingent on a preliminary survey of the land to see if it is comprised the area stated in the tax declaration, the right to particular performance emerged only after the plaintiff discovered the completion of the survey. Regarding money claims arising from an employment contract, which should prescribe in 3 years from the time the cause of action accrued, the cause of action would arise from the date the employer made a definite denial of the employee's claim, because prior to such denial, it is deemed that the issues had not yet been joined because the employee could still have been reinstated. In a contract reformation action in which the plaintiff alleged, among other things, that the contract was one-sided in favor of the defendant and that certain events had rendered the arrangement inequitable, the cause of action for reformation would arise only when the contract appeared to be disadvantageous. The type of the commodity sold plays a significant role in deciding when the cause of action has arisen. When fuel oil is provided in drums, for example, a buyer readily assumes that the agreed-upon volume can and will be contained in the drums. He is not expected to meticulously measure each and every delivery. In the case of short deliveries, the cause of action will arise only when the same is discovered with confidence. Let's now proceed to the injury, damage, and damages distinguished. Injury defines as the legal invasion of a legal right, while damage is the loss, hurt, or harm which results from the injury. But what is the existence of one without the other? There may be injury without damage and damage without injury. First is there should be proof of loss for injury. Second is the liability for damages of a person for exercising his legal rights. This simply means that in order that the law will give redress for an act or omission causing damage, that act must be not only hurtful but wrongful. That's it for my report. I sincerely appreciate your attention. That brings us to the end. Hoping that you gained something from my discussion. See you on the next one.